Today, I would like to discuss a couple of things with you. And while preparing for my subject as well, I'm little distracted for a particular incident happened in recent days. Today, I want to talk with you, share my thoughts over this, and this video could be a little longer. So I would request to have a little patience and understand my thoughts while I'm preparing my studies as well. So it's all about a particular case happened in a recent day on the Delhi riot case 2020 Supreme Court's verdict. Particularly, two people has been denied with their bail. Umar Khalid and Sarjil Imam. Preceding to that, JNU protest erupted out. All media proceedings are going on, media coverage is going on, and the way JNU protest has been happened, it is pretty disturbing. But all I understand, they are students, they are in JNU, and while you are studying and you are protesting the way you did, that is not acceptable. Some people, some left wing activists, they are supporting the way, the cause, but being a student, somewhere I'm a little disturbed on this. So what has happened, like if you have seen on couple of days back, last week, in JNU, left wing students from SFI, DSF, AISA gathered, and they did some protest. They told it like they are marking an anniversary of a 2020 JNU attack, but in between their like that particular night turned charged our slogans against PM Modi, Amit Shah. Slogans came like Modi tera kabar khudega, Shah tera kabar khudega in JNU campus. They are demanding basically the release of Umar Khalid and Sarjil Imam after Supreme Court refused the bail in the 2020 Delhi riots case. And it has been already established like these two people are the architect behind this Delhi riot, and courts has established that already. But still, some politicians, some particular bunch of people are commenting on that. You're allowed for comments, but the way you are protesting, that shows you have no respect towards the judiciary, or you are questioning the judiciary. Questioning is okay, but the way you are conducting it, it's not acceptable. Somewhere, what I think like. So I'm just wondering, like, this is a free speech or it's a anti-national politics. So while I'm preparing for my assessment on contempt of the court, somewhere I feel like these two incidences. I mean, the subject what I'm learning these days and this particular incident had some connections. Being a law student, I thought I should try to analyze the case and in perspective of contempt of the court, or is there any possibilities or something. So when I go back and see, the university has alleged that certain slogans amounted contempt of court and violated JNU code of conduct. So they have prompted for a police complaint and an internal inquiry. The way we can see through different media grounds, the discussions, the activities happened on that particular evening. Somewhere I feel like if that is the way they represented, doesn't it looks like a criminal touch? The judiciary system or different authorities have rights, or cannot they control it, condemn it, or maybe if there are some nuisance, or they are out of the track, or somewhere like compromising with the public moral, public confidence on the judiciary, cannot some actions or punishments needed to be implied? ମୋ ମନ ଭିତରେ ବି ବହୁତ ସାରା ଜିନିଷ ଚାଲୁଛି ଯେତେବେଳେ ମୁଁ ମିଡ଼ିଆରେ ସବୁ ଜିନିଷ ଦେଖୁଛି, ୟାର ଆନାଲିସିସ୍ ଦେଖୁଛି, ଡିଫରେଣ୍ଟ ପର୍ସପେକ୍ଟିଭରୁ ଯେତେବେଳେ ଡିଫରେଣ୍ଟ ପର୍ସନ୍ସ ସେମାନଙ୍କର ରିଆକ୍ସନ୍ସ ଆଉ ଥଟ୍ ପ୍ରୋସେସ୍ ସେୟାର କରୁଛନ୍ତି, बहुत सारा कंट्राडिक्शंस भी मतलब फील हो मतलब एक्सेप्ट कर पाउनी या भितर गोटे पर्टिकुलर एरिया जोटा मतलब फील हो आई वुड लाइक टू टेल यू समथिंग हम माने स्टूडेंट्स गोटे कॉलेज गोटे यूनिवर्सिटी की जाउछे पाठ पढ़िया पे हम माने एडल्ट हे सारलेनी प्रोफेशनल स्टडीज करूछे एंड गोटे यूनिवर्सिटी भितर रही की जेतेबेले हम एई भलिया एक्ट्स करूछे तो सेठी गोटे क्वेश्चंस आसुची कि हम सेठी पाठ पढ़िया को जाइछे या राजनीति करिया को जाइछे जदी राजनीति करिवार अछि पाठ पढ़ा सारी की ओपन फोरम को आसिकी पब्लिकली जदि आपण राजनीति करछन दैट इज ओके किंतु एई जो किछिटा पॉलिटिकल वेंडेटा को नै कि व्हेन यू आर डूइंग इट फ्रॉम योर यूनिवर्सिटी कुड नॉट एक्सेप्टेबल होनी इंडिया भीतर बहुत सारा यूनिवर्सिटीज अछि आ मु को जगह रे देखुनी कोनोसी यूनिवर्सिटी या अन्य कोनोसी यूनिवर्सिटी स्टूडेंट ए एस्पेक्ट रे कोनोसी प्रकार डेमोन्स्ट्रेशन करछंती अथवा जेएनयू रो ई प्रोटेस्ट अगेंस्ट कोड किछि कमेंट अछि और से माने ता अगेंस्ट रे हो इबा तार फेवर रे हो कौन प्रोटेस्ट करछंती या फिर कौन प्लेटफॉर्म रे से मानकर वॉइस रखछ तो जतेबेले एठी डिस्टर्बेंसेस देखुची स्लोगन्स देखुची मते कोट गोटे फील होउची कि कोन एठी जुडिशियरी रे किछ इन्वॉल्वमेंट नाही या फिर हमरो लीगल प्रोसेस रे सेमिति किछि अछि कि से माने जो चार्जेस आणुचंती दैट इज करेक्ट और नॉट करेक्ट इफ करेक्ट दैट इज ओके इफ नॉट करेक्ट देन तांगो पई कोन किछि पनिशमेंट नाही सो टिके आउट के एनालिसिस करबा जतोले मु कंटेम्प्ट ऑफ कोर्ट रो कथा होउची कंटेम्प्ट कोन व्हाट इज कंटेम्प्ट जदि मीनिंग वाइज जिबा कंटेम्प्ट मीन्स द फीलिंग दैट somebody or something doesn't deserve or any respect or without any value माने गोटे एक्ट या एक्टिविटीज जदि कहूची कि गोटे लोक हुंतु या फिर किछ गोटे जिंस हो which doesn't deserve any respect or it has no value connecting words similar words disdain means like someone is beneath you scorn where you are doing open mocking worthless when it says it has no value and defiance says like you are disobeying or disrespecting an authority at a common meaning of contempt generally contempt court favor रे या court related terms रे आसे और generally लोक माने बुझंती contempt of court तो जदि आमे कोर्ट या जुडिशियरी प्रोसेस को देखिबा कंटेम्प्ट ऑफ कोर्ट पूर्वरु मोटे कोर्ट या जुडिशियरी रो गोटे कोर ऑब्जेक्टिव फिलोसॉफिकल रैशनल विषय रे कहया चाहिए सबु लॉ जोटा हमर अछि कोर्ट कंटेम्प्ट अगेंस्ट इट हैज अ कोर ऑब्जेक्टिव एंड a philosophical rational particular चारिटा aspect रे कामे कथा हवा one is like maintaining public confidence court judiciary system उपरे जदि पब्लिक रो कॉन्फिडेंस रहबनी देन द एंटायर मोरल विल बी अ फेलियर एंड एटा लॉ रो दायित्व कि एई रेस्पेक्ट टा केमिति रहिबो ए कॉन्फिडेंस टा केमिति रहिबो तापे से माने रेगुलेशंस और रूल सेट करन एंश्योरिंग रूल ऑफ लॉ जदि लॉ रो रूल रहउनी जदि सिटीजन्स लॉ अवॉइड करूना हंती देन अगेन इट कुड बी अ डिसरप्ट तो गोटे सोसाइटी को गवर्न करिया पई रूल्स अछि रूल ऑफ लॉ अछि व्हिच रेगुलेट्स कोर्ट ऑर्डर्स एंड जजमेंट्स ए कोर्ट ऑर्डर्स जजमेंट्स नीड टू बी obeyed and ethi jetola me contempt power kotha कहबा it serves as a necessary mechanism to enforce compliance with judicial directives and prevent any individual or entity from placing themselves above legal process guaranteeing judicial independence jodi gote judiciary ro independent performance pai space nahi then it could be a catastrophic situation so judiciary must be able to perform its duties and decide cases without any fear favor affection or ill will. The law protects judges, the judicial process from external interference, pressure, unwarranted and malicious attacks. And then fourth point is like preventing obstruction of justice. जतबे गोटे कोर्ट या गोटे जुडिशियरी प्रोसेस गोटे पनिशमेंट करूची गोटे वर्डिक्ट दउची तो तार एडमिनिस्ट्रेशन रे तार लॉ डेलीगेशन रे कोनोसी प्रकार obstruction no asu it needs to be prevented for an example like witness tampering ho disrupting courtroom decorum ho ki kichi material open forum re publish ho which affects judicial administration now next come to contempt of court kono any act that lowers the dignity of the court or obstructs the administration of justice this is basically a legal concept that refers to any conduct act or publication that demonstrates willful disobedience disrespect or defiance towards the authority dignity and functioning of a court thereby obstructing the administration of justice contempt of court pai amara india re contempt of court act 1971 achi previously it was 1952 which basically defines limits and regulations of contempt power of courts article 129 and article 215 129 और 215 एथिरे कोन अछि article 129 रे एटा कोहाइछि SC supreme court shall be court of records article 215 रे कोहाइछि high court shall be court of records तो the courts which has its own court of records they can bring in contempt of court एबे ए जो प्रोटेस्ट कले JNU पिला माने सो सुप्रीम कोर्ट अगेंस्ट रे एटा कोन कंटेम्प्ट ऑफ कोर्ट सो व्हाट आई सी लाइक प्रोटेस्टिंग अगेंस्ट Supreme Court bail denial is not automatically contempt of court. However, the nature and manner of the protest can cross the line into the contempt. That means ଏ ଜିନିଷ it's not has been established yet as a contempt of court, but ଯେମିତି JNU authorities କହିଲେ there are couple of slogans which leads towards contempt of court, so there must be a line and probably this guy has crossed that line which is going towards the contempt of court. ଏବେ ଆମ କନଷ୍ଟିଟ୍ୟୁସନ ରେ କ'ଣ ଅଛି ଆଉ contempt of court act କେମିତି ତାକୁ ଡିପ୍ଲୟ କରୁଛି? contempt of court act 1971 এটা କ'ଣ କହୁଛି? contempt ଦି ପ୍ରକାରର, ଗୋଟେ ସିଭିଲ କଣ୍ଟେମ୍ପ୍ଟ, ଗୋଟେ କ୍ରିମିନାଲ କଣ୍ଟେମ୍ପ୍ଟ. କଣ୍ଟେମ୍ପ୍ଟର ଡେଫିନେସନ ସେକ୍ସନ 2 ରେ କୁହାଯାଇଛି, ସେକ୍ସନ 2B ରେ କୁହାଯାଇଛି ସିଭିଲ କଣ୍ଟେମ୍ପ୍ଟ, ସେକ୍ସନ 2C ରେ କୁହାଯାଇଛି କ୍ରିମିନାଲ କଣ୍ଟେମ୍ପ୍ଟ. ସିଭିଲ କଣ୍ଟେମ୍ପ୍ଟ କ'ଣ? ଜେନେରାଲ ପର୍ପସ୍ where is willful disobedience is there. This willful disobedience କ'ଣ? ଗୋଟେ କୋର୍ଟ ଗୋଟେ ଅର୍ଡର ପାସ୍ କରିଛି, ଗୋଟେ ଜଜମେଣ୍ଟ କରିଛି, ଗୋଟେ ପ୍ରୋସେସ ଏଷ୍ଟାବ୍ଲିଶ କରିଛି and someone is not abiding by that or obediently follow karuni. Reason could be anything, but apana janiki karunahanti, that is called like willful disobedience. For an example, gote marital dispute divorce case and it has been ordered, one party need to pay the maintenance of the other party, but the party fails to do the payments. Or suppose there is a scenario where court orders on a particular case where a particular person or an entity has to pay a fine, but somebody is avoiding that, so that is willful disobedience. Yar against re punishments kono? Punishment could be fine, could be compounded, jail provisions achi ya both bhi hei pare. Severity kete eteda severe nuha, apano avoid karichhanti, apano pay karinahanti, you may lead to imprisonment. But by that, if you are paying the fine amount or jahabi due diligence achi, if you are doing that and abiding by the order of the court, then this is avoidable. Next comes criminal contempt. This is the severe side. Criminal contempt kono? First is like if you are scandalizing or like an act scandalizes or tends to scandalize the authority of any court, lowers or tends to lower the authority of any court, prejudice or interferes with any judicial proceedings. Here the key point is the law protects the institution and its ability to function without any fear and pressure, not the individual judges or their decisions from public criticism. So criminal contempt kotha jetole ame kahiba, eti punishments kon achi? Fixed fines, imprisonment, both for a specific duration and of specific amount, independent of compliance. Ebi jodi ame eta ko compare kariba in terms of like civil contempt, civil contempt re this is basically a coercive in nature, whereas criminal contempt is punitive. Nature kono ki like civil case contempt aspect re there is willful disobedience or breach of an undertaking. Criminal contempt re acts undermining court's dignity and its respect, and where it obstructs its proceedings or its justice or judiciary acts, where basically it disrupts the court's proceedings or court's function. Ethire dita aspect asuchi, civil contempt ho ya criminal contempt ho, sethire how somebody is like availing that against re kemiti file kara jaye, procedures kon. Civil re it's a less formal, konos bhi party yaku raise kar paribe, but they have to and like establish the standard of proof. Apane jetobale gote question raise korchanti, then you have to give a clear and convincing evidence. But criminal contempt re generally the courts initiated suo motu and individual party kari paribe, but when they will do that they have to take an consent from the AG. Without any AG consent, without any standard of proof, where you have to establish like it's a beyond a reasonable doubt, you cannot go towards go against a criminal contempt. So next comes contempt kono crime. Yara nature kono, like is it quasi criminal? Jodi ame eta dekhiba, contempt of court is generally not classified as a traditional crime but rather a quasi criminal. Why quasi criminal? Either it a civil contempt ho ya criminal contempt ho, both the scenarios re the punishment side jodi ame dekhiba, there are provisions of fines and imprisonment or both. So it basically resembles a criminal sanction, most notably for the like imprisonment punishment. So say aspect re we can say that this is a quasi criminal in nature. The main reason is like e jo contempt ho, it is like inherent and aims to uphold judicial authority to process and potential consequences like which borrow heavily from the criminal justice. Jo amara criminal justice framework achi, to sethire when there are provisions of fines and imprisonment, dite jaga contempt re similar punishments achi, so in that way it is quasi criminal in nature. Now I would like to discuss three or four keywords which is coming more prominently on this aspect. ଆମେ ଗୋଟେ word ଶୁଣିଛେ scandalizing a court. Scandalization କ'ଣ? So that refers to any publication, word spoken, written, signs, or any act that attacks the integrity of individual judges or the court as a whole, thereby like lowering the authority of public confidence in the administration of justice. Example ଆମେ ନେଇପାରିବା like publishing a scurrilous newspaper article calling a judge an impudent little man, maybe who's empty-headed or unfit for the bench. Another example could be making public statements that allege that entire judiciary is a corrupt or politically biased. Maybe in a court trial, an advocate is using intemperate and abusive language against judicial officers. So these aspects is like scandalization of court. Next, I'm going to word sunithila willful disobedience. What is willful disobedience? This is particularly in context of civil contempt. That means like an intentional, deliberate failure to comply with a valid judgment, order, direction, or writ of a court, or breach of an undertaking. Example, a person refusing to submit financial records to the court as ordered in a divorce case, or maybe a statement where it is directed to pay maintenance towards the party, and knowingly or unknowingly you are avoiding that, or the first party is avoiding on those payment affairs, or a party obtaining a favorable court order by giving an undertaking and then intentionally failing to honor that promise. Third point is like prejudicing a fair trial. ଯେତେବେଳେ ଗୋଟେ court proceeding ଚାଲିଛି, ଗୋଟେ fair trial ଚାଲିଛି, ସେ condition ରେ if any action or publication that interferes or tends to interfere with the due course of a judicial proceedings, creating a real risk of bias or against any party, witness, or the juror, this act goes towards a criminal contempt. Example nahi pariba, a newspaper publishing sensitive details about a defendant's past criminal history, maybe threatening a witness or a party involved in a case to force them to give false evidence, or a juror conducting their own research into a case and sharing that information with other jurors, compromising the integrity of the trial. These tinta aspect are like prominent areas like which leads to our contempt of the court. Ebe ei jo scenario heichi JNU aspect re ethi dita jinsa asuchi when they say they have right to protest and there is freedom of speech. Ebe court ro scenario kono ki court how court sees that, and jodi gote contempt asuchi how it balances when an aspect says like there is a right to speech, right to expression, but court sees as a, or some allegations are that this is a contempt of court. Court aku jetola judgment kore kemti balance kore, it always try to balance it, and ketata aspect it tries to establish that ki eta actually a contempt or etada extent renewal, that there is a balancing mechanism which is dependent on couple of points like fair criticism versus contempt. Jo our article 19(1)(a) it says ki whether this act is a malicious attack that attacks court jo proceedings achi ya court operations achi seta gote obstruct karuchi ki nahi, whether it is scandalizing the court. It got a first aspect where it says whether it's a fair criticism or it is a criminal contempt or a contempt basically. Then another point is like reasonable restrictions. This is like article 19(2) re eta bi kuaichi there is restrictions for free speech. Apano 19(1) re achi like you have rights of free speech, apano express kar par we can protest, but 19(2) subsection re eta bi kuaichi there are some restrictions on that ki court eta check karibo ki apano jetebale free speech katha kouchanti whether that undermines the administration of justice, ensuring trials remain fair and unbiased. Apanankara katha, apanankara freedom of speech court ro actions ku compromise karuni ya फिर ताको कौनसी वे अफेक्ट करुची या बायस करुची. जस्टिस को प्रोटेक्ट करिवार भी अछि. आर्टिकल 21 says like the power to punish contempt ensures judiciary can function fearlessly, protecting the accused's rights to a fair trial. ए भितरे कोर्ट प्रोपोर्शनैलिटी और ट्रांसपेरेंसी को भी चेक करे, एंड एई चारिटा एस्पेक्ट ऊपर कोर्ट बैलेंस करे डिसाइड करिया पई कि whether the free speech or the speech or the act is a contempt or not a contempt. JNU protest rate, what they are demanding, they are saying like this is very reasonable to criticize judgment. तांको हिसाब रे तो there comes a question कि can fair and reasonable criticism of a judgment amount to a contempt? लाइन कोटी टाणिबा परमिसेबल क्रिटिसिज्म रा अलाउंस अछि आपण क्रिटिसाइज करि परिबे बट इट डिपेंड्स ऑन द इंटेंट लैंग्वेज एंड द पोटेंशियल इफेक्ट ऑफ द स्टेटमेंट ऑन द एडमिनिस्ट्रेशन ऑफ जस्टिस एई एस्पेक्ट रे देयर इज अ बैरियर एई सिनेरियो रे जजेस एंड कोर्ट रो रोल केमती अछि सेटा भी हमकु टिके देखिबा को पड़िबो जनरली जेतोला मे कंटेम्प्ट विषय रे कथा होचे जजेस तांकर कंटेम्प्ट पावर को बहुत कॉशियसली दे यूज इट like someone eta dekhanti ki that criticism is whether it substantially interferes with the due course of justice ethi public ro confidence intact achi ki eta compromise hochi ethi dita aspect kotha koibi when this kind of scenarios comes semane gote test karanti when comment comes a test hela eta ki like whether the allegations or a act or impact this is an imminent danger or किछि देर आगुरु आमे राइट ऑफ एक्सप्रेशन कथा कथा हेले एंड राइट टू अ फेयर ट्रायल कथा कथा हेले यार कनेक्टिविटी एंड या भीतर जो फाइन लाइन कथा भी हम टिके डिस्कस करले एबे जदी विल गो बैक टू दिस जेएनयू प्रोटेस्ट एरिया इफ जेएनयू प्रोटेस्ट वाला सिनेरियो वेयर द प्रोटेस्टर्स आर सेइंग दिस इज अ रीजनेबल क्रिटिसिज्म अगेंस्ट द डिलीवरी ऑफ द कोर्ट तो अपन कोन भाबचंती लाइक कैन फेयर एंड रीजनेबल क्रिटिसिज्म ऑफ अ जजमेंट अमाउंट टू कंटेम्प्ट वेयर इज द फाइन लाइन कैन वी ड्रॉ दैट लाइन यस ऑफ कोर्स अपन को चतोड़े फ्री स्पीच free protest rights achi there are couple of underlinings as well which avoids or like obstructs going towards a contempt apna kahi paribe but responsibility sangare kahibe apna criticize kari paribe apna fair criticize kar paribe to se hisab re gote fair and reasonable criticism of a judgment does not amount to contempt of court but the fine line is it depends on the intent language and the potential effect of the statement on the administration of justice आपनकर कथा आपनकर act जदि कोर्ट प्रोसीजर्स जदि जुडिशियरी एडमिनिस्ट्रेशन रे obstructions क्रिएट करछि अफेक्ट करछि बायस करछि देन यू आर क्रॉसिंग दैट फाइन लाइन नेक्स्ट कम्स लाइक कोर्ट रो जज मानकर रोल कोन जेतोले कंटेम्प्ट प्रोसीडिंग हुए तो जजेस मानकर हाथ रे कंटेम्प्ट पावर थाए and they use it with a good caution semane dita particular areas go focus karanti while discharging their contempt power they do a test particularly like they try to see it as a real danger or a present danger so whether it's a momentary or it has a bigger impact long term impact and whether this criticism is like a substantially interfere with the due course of justice on that aspect like many proceedings initiate karanti and basically these judges are the gatekeepers ethi goal hela ki like to protect the public's confidence in the institution of the judiciary not to shield individual judges from criticism ei jo system bana hi chi contempt proceedings ethi individual judges manako upare जदि कौन सी क्रिटिसिज्म आछि ताकू प्रोटेक्ट करिया पई न थाए रादर ग्रॉसली द ऑब्जेक्टिव की हमर जनरल पब्लिक सिटीजन्स मानकर कॉन्फिडेंस कोर्ट ऊपर रहू जेते बडे टेस्ट कथा कहूची जजेस मानकर रोल कथा कहूची they generally evaluates on two aspects gote hela ki the link to the truth of the defense truth ra establishment kete achi ta upare depend kare semanakar activities judges manakar activities they run a particular real and present danger test jota be mu kahili impact semane check karanti it is a real threat or this is just a present danger ei dita aspect re semanakar activities depend kare while they proceed on any contempt cases ethi the fundamental goal is ki like this is an institutional this is not for personal like institutional priorities there like it ko personal comments ko nei ki ke baby court contempt kareni amaro judges manankar gote bahut badhiya nature अछि they are basically thick skinned se mane dekhanti ki jo choto jinso choto act ତାଙ୍କୁ କିଛି ଫରକ ପଡୁନି and being a part of judiciary system standing strong and neutral is very much important and ତାଙ୍କର ଏଇ behavior shows କି like କେତେ ଭଲସେ ସେମାନେ ସେ value को hold କରିକି ରଖୁଛନ୍ତି they have been instructed like ଆମର judiciary practices ରେ ଅଛି କୌଣସି lawyers କେବେ comments को personally ନିଅନ୍ତି they always take it institutional ଯଦି ସେଠି କିଛି institutional moral respect ରେ କିଛି effect ପଡୁଛି then that could be tried. Next comes आम जो कथा क्रिमिनल कंटेम्प्ट रे जनरली द केसेस रजिस्टर्ड और जो केस प्रोसीडिंग्स हुए से गुड़ाक सुओ मोटो हुए सुप्रीम कोर्ट जज हो गले एंड High Court, so Supreme Court and High Court basically criminal contempt context रे they go suo moto. तो टी Attorney General हे गले, Advocate General हे गले, they generally acts as a gatekeeper in criminal contempt cases, granting हो या denial of consent हो, तो सेटा तांको ऊपर depend करे. Criminal contempt proceeding scenarios रे, हमारो Attorney General and Advocate General for High Courts have like particular roles. They must give written consent for a private individual or an individual to start contempt proceeding. So contempt proceeding रे जो authoritative guardians हमने कही परिबा AG and additional like Advocate General. Generally से मैंने कौन पे करती कि filter frivolous petition बहुत सारा petitions आसे तो their role comes where they will deny it or give permission for a court trial. Merit basis access करा जाए. As an officer of the court, the Attorney General or the Advocate General independently assesses if the alleged act genuinely amounts to contempt, protecting fair criticism while upholding judicial authority. Public interest रे they are the initiators. ଯେତେବେଳେ ଆମେ suo moto case କଥା କହିଲେ ଯେତେବେଳେ ସେମିତି କିଛି contempt ହଉଛି criminal contempt context रे both Attorney General and Advocate General can initiate proceedings directly in cases of like a significant public interest, generally public interest रे. Next comes the punishment. Contempt of court against रे. What are the punishments are there? Both the scenarios रे civil contempt हो, criminal contempt हो. सेठी simple imprisonment अच्छी, rigorous imprisonment अच्छी. Civil scenario रे that there could be simple imprisonment. Criminal contempt रे rigorous imprisonment. Forfeiture of property भी है पर and of course both the scenarios रे fine is there. A monetary penalty is there. एबे modern approach रे recent approach रे there are like a couple of additions as well. जेमती community service है गला as a punishment. Court orders for some community services. Offense repeat हेले fine compound ही पर compounding of fines is there and जेमती हमें आगुरी डिस्कस करते सिविल कंटेम्प्ट रे आपण फाइन्स या ऑब्लिगेशंस को फुलफिल करिकी पनिशमेंट रू बाहरी परिबे बट क्रिमिनल कंटेम्प्ट रे दैट इज एब्सोल्यूट एंड पेनल्टी यू कैन नॉट अप्लाई और आपण सेठी अपोलॉजी करि परिबेनी दो यू कैन सबमिट apology letter but generally criminal contempt scenarios re court entertain karen but civil scenario re apna through applications or like petitions you can modify your punishments. So coming back to JNU protest context re ebe next kotha la bele let us examine the right to protest versus contempt. Right to protest kono like under article 19 of our constitution citizens have fundamental right to peacefully assemble and protest. You can criticize a judgment or order calling it wrong, unjust or demand its review. For example, like you can do a march holding placards and where it says like we disagree with the bail denial or justice denied is a form of dissent, not a contempt. Lines cross katele hochi contempt pai when right of protest crosses the line into the contempt. The protest becomes potentially contemptuous if it imputes motives to the judges. For an example, the judges are biased, the court is acting for the government. If you are using scandalous, abusive or intemperate language against the judge or the institution, if you are attempting to threaten or intimidate the judiciary to change its decision or its action, if you are alleging corruption or lack of integrity without any credible basis, if you are organizing protests in a manner that directly disrupts court functioning or attempts to besiege the court premises. Let us apply this to a hypothetical JNU protest on bail denial. Scenario scenario A, Jyoti, let us examine what could be the scenario. A peaceful gathering at JNU where speakers and placards express dismay at the bill denial, argue the legal merits, demand a review, or even call the judgment a setback for democratic rights. This is a political and legal dissent. In this scenario, this is not a contempt. Scenario B, if the protest features speeches or slogans personally attacking the judges, the bench is puppet of the regime, quoting, alleging malafide intentions or making unsubstantiated allegations or corruption. If the protest morphs into a call to storm the Supreme Court or uses violently threatening language, it clearly crosses the line. There is risk of contempt. এটা যদি সিনারিও हुए তাহলে there is risk of contempt. But actually କ'ଣ ହେଇଛି? If you deep analyze, the university administration has alleged that some slogans amounted to contempt of court and violated the code of conduct. ମୁଁ ଆଉ କିଛିଟା example ଦେବାକୁ ଚାହିଁବି. Let's say ଗୋଟେ hypothetical scenario where a leading newspaper publishes a front page article alleging corruption in the higher judiciary without citing any specific proof. Is this a contempt? Contempt of court depends heavily on jurisdiction specific laws, the intent of the publication, and the actual impact of the article on the administration of justice. Ethi jodi ame key factor consider kariba, scandalizing the court, interference with justice, balancing freedom of press, lack of proof of malice. To se hisab re jodi eta dekhiba, it is affecting. But when I said there is no citation or any proof, then say condition re it constitutes contempt of the court, because being a news media, without any responsibility, you have mentioned a statement where there is no citation, there is no proof, so it's a contempt. Another scenario, a lawyer in a heated argument tells the judge, your order is biased and you are incapable of understanding the law. Is it a contempt? Yes, this is very likely to be held as criminal contempt. Reason, scandalization of court, insulting the judge. How would a special scenario on this current context of digital age? Let's say there is a scenario when a Twitter handle tweets criticizing a recent judgment in strong derogatory language, and it has barely like 100 followers or 500 followers. This tweet gets little engagement. Should the court take suo motu cognizance and trial it? Kon court eটাକୁ contempt of court रे नब कोन भाबुछन्ती कोन हेई परिबो? जो कथा में पूर्वरु कथा हेतले, there are two aspects की present versus actual damage, actual versus the potential harm. Say aspect रे court will check like where there is a real or substantial risk of interference with judicial process achi na nahi. A post रे if this has a minimal reach and unlikely to meet the higher standards, so court won't take cognizance. I got a principle achi that is called de minimis principle. That means the law often doesn't concern itself with trifles. Choto jinso ko court care kareni. A tweet with only 100-500 followers and a little engagement is unlikely to substantially interfere with the administration of justice or widely erode public confidence. Yar impact upre depend kare. So if that impact is on higher side and this is an actual harm, then the courts take cognizance. Going ahead, mutinita case law विषय भी डिस्कस करिया को चाहिए on this context. गोटे केस है पर्सपेक्टिव पब्लिकेशन वर्सेस स्टेट ऑफ महाराष्ट्र 1969. ए केसटा हमर 1952 एक्ट परर जिनस बिफोर 1971 amended act. तो एथिरे कोन थिला, the fact is the case centered on an article in mainstream concerning Bombay High Court judge suggesting a connection between a bank loan and the judge's judgment in a libel suit. The Supreme Court held the editor is guilty, concluding the article implied improper motives beyond acceptable criticism. 1952 act परर केस एटा. It is a very much landmark case. आमे मझिर tendency test कथा हेतले where the court discuss about or looks after actual versus imminent risk. Dita case गोटे famous Arundhati Roy case 2002 and Prashant Bhushan case 2020. Dita prominent case after 1971 amendment परर case एटा, and these are two important cases. एटा को डिस्कस करिवार रीजन हैला कि सेम सिचुएशन रे similar situation रे similar trial रे दिटा डिफरेंट जजमेंट्स आसथिला लाइक गोटे जगह रे कोर्ट बहुत कंडेम्ड करिथिला बट गोटे जगह रे कोर्ट एप्रिशिएटेड बट दिटा जाक जेहेतु क्रिमिनल कंटेम्प्ट थिला सेठी पेनल्टीज लागिथिला पनिशमेंट ऑर्डर हिथिला बट डिफरेंसेस लाइक गोटे जगह रे कोर्ट एप्रिशिएटेड गोटे जगह रे कोर्ट स्ट्रांगली कमेंटेड अरुंधति राय 2002 केस एथिरे थिला कोन की लाइक अरुंधति राय हैज अ एफिडेविट क्वेश्चन द कोर्ट्स हैंडलिंग ऑफ द सरदार सरोवर डैम which led to a suo motu contempt proceeding. Court found it guilty, stating her affidavit scandalized the judiciary and diminished public confidence. Reason kono ki though she has claimed of free speech, but it led towards a more nuance through steel firm misrepresentation. Bias karibaro chesta. Arundhati case 2002, sorry, Arundhati Roy case 2002. But at the same time, Prashant Bhushan case 2020, the court said it like a magnanimous charity. The reason gone कि प्रशांत भूषण केस रे a tweet criticized the judiciary, particularly the chief justice role in lockdown and alleged corruption. तो एथिरे भी court suo motu cognizance नहीं थिला and viewing tweets as a malicious attack on judiciary integrity, they proceeded for a criminal contempt. एथिरे same punish सही थिला 1 day imprisonment and a fine, but court रो stance थिला कि while upholding its contempt power and distinguishing between fair criticism and malicious attack, it showed some evolution be recognizing the need for magnanimous charity, but still imposed a punishment for what it deemed destabilizing attacks and imposing imprisonment. Apna fair criticism karuchanti, that is acceptable, but the way apna kale and jo impact padila sethipai this is a criminal contempt. Arundhati Roy case re it told it's malicious, but Prashant Bhushan case re it told it's constructive. So we discussed 3 cases on contempt of courts, and I guess I tried to cover a lot of on this contempt of court, its procedures and proceedings. So let us conclude. If we'll go back due to I start करथले जोटी मो टिके डिस्ट्रैक्ट होथली ए JNU के सिनेरियो रे सेटू ही टिके कनेक्ट करबी what I understood कि the legal boundary is clear, protest the decision, debates logic, demand its reversal. This is a democratic discourse. Attack on the decision maker, impugn the integrity or attempt to intimidate the institution, these are the risks for contempt. So basically हमें contempt of court पूछले यार proceedings पूछले यार punishments पूछले and आपको relate कले current JNU protest case सांगरे तो JNU protest रे बे हेला कौन like let us conclude going there. तो finally the FIR under section 352 intentional insult with intent to provoke breach of peace charges लागिची 353 section 1 statements conducing public mischief 3 subsection 5 common intention of BNS. These are like all related towards the slogans raised during this student protest, and finally protestants manango upare charges lagichi and couple of people has been arrested. On the other hand, 2020 right case re the Supreme Court had denied bail for the architects of the case, and what I feel like कि if I'll go back and JNU protest opere, what my observation is कि JNU protest against Supreme Court bail denial is not by itself contempt of court. It is an exercise of fundamental right to dissent. The contempt risk arised entirely from the content and form of the protest. The way they protested, जो slogans देले, the way रे सेमाने represent कले carry कले, they cross the line towards the contempt of the court. The legal boundary is very clear, like protest, the decision, debate, its logic, demand, its reversal. This is a democratic discourse. But attacking the decision maker, impugn their integrity or attempt to intimidate the institution, these are the risks for contempt. In a sense, the law, the judiciary system draws a line between criticizing a judgment and scandalizing a court and potentially going towards a contemptuous scenario, a criminal contempt. Thank you very much. If I had done something understanding or like make you understand on this subject and jodi kichhi mo clarity dei parichi, then I'll appreciate your time, and that's it. Thank you very much. Have a great day ahead. Thank you.